or anything?
I don't have a meeting,
Okay,
what's it called, a waiting room.
good. Okay.
So anybody can just jump
Good
in whenever they
morning.
come on.
Okay.
So I want
Um,
to thank everyone for taking time out tonight to learn about wills and trusts from our managing attorney, Shima Freeman. She is based out of Texas now, formerly from the great state of Florida.
All
So
right.
I'm going to let her go ahead and finish her introduction. And you can share the screen, right? You do have
Yes,
screen
let
access,
me
I
go ahead
believe.
and do that now.
Okay. And do you want them to ask questions as you go, or you want them to wait till the end?
We can kind of do both. So I always like to start off these calls with asking, and you can come off mic or put it in the chat, whichever one you're more comfortable with. What is it that you're wanting to learn from tonight? If you have specific questions, you can go ahead and throw them in now. And um, I designed these so that I talk as little as possible and allow time for all of your great questions. So if you have questions during the presentation, go ahead and come off mute or put them in the chat so you don't forget them. Otherwise, we'll just do questions at the end.
Okay.
Sounds good?
Sounds good. And I'll monitor the chat and let you know if any questions come in.
Perfect. I appreciate that. So yeah, tonight is Estate Planning 101. This is a very broad overview of estate planning. So I'll go through, it's kind of broken up into two parts. The first part is basically defining estate planning, probate, things like that. And then the second half is really going through the different parts of estate planning and the advantages, disadvantages, and benefits a little bit. All right. So, who is Eurethi Law and who am I? Eurethi Law is a law firm. It's a Florida law firm, but we also have offices here in Texas. We are completely dedicated to estate planning, probate, asset protection, and real estate. Um, and our main goal and mission is to make sure that we help clients with their estate planning so that they have uh, the least amount of uncertainty and um, increase clarity in their probate process and also their estate planning process. Everything that we do is customized to your specific assets and goals. So we're not like a one size fits all type of firm. Uh, and then a little bit about me. I have done many careers. I don't know what iteration of careers I'm on right now, but I also hold a PhD in material science engineering with a specialization in biomaterials. Most of my work was in cancer research, uh, and I started off kind of in patent law and went to law school at George Washington in Washington, D.C. And when I was in grad school, my mom actually had a heart attack and a heart transplant. And all through managing grad school, law school, working remotely, I was also her primary caregiver during that process. So I'd spend a lot of my time going back and forth between Florida and DC. And she passed a few years ago. And that's what actually spurred me into this field of estate planning and probate. Because now, 3 years later, we're still kind of dealing with some miscellaneous things there for estate. And it's my goal and my mission to make sure that people have a lot of clarity in their estate plan so their families can grieve properly and are not stressed out and have anxiety about the assets and the distribution and just the process in general. So I've talked about this a little bit, but why is this conversation? Why does it matter? And I want to make sure we understand that estate planning is not solely about death. It's about control, protection, peace of mind. Um, it's really about decreasing that family burden, like I said before. So if you have any kind of if you own anything, then you have an estate. And if you don't have a plan, then the state of Texas already has a plan for you. So every state has estate codes is what they're calling. It's written into law what happens to your property and your assets when you pass. So if you don't have a plan, then the great state of Texas will decide what happens to your estate. So what is an estate? I think what most people think of when they're, are considering what an estate is, it's their house. Most people think you have to have, you know, millions of dollars in order to have an estate plan. And it's really not the case at all. Your estate includes all of your real estate, your bank accounts, any businesses, and even your personal property, right? And now with the increase of like cryptocurrency and things like that, is including your digital assets. So, like I said, if you own anything at all, you technically have an estate, right? Because all of your personal property, so down to your furniture in your house, is part of your estate.
Hmm.
And I'm going to move you guys out the way so I can see my slides a little bit better too. So what is estate planning? It's really just the process of legally deciding who receives your assets, and who makes the decisions if you cannot make decisions. And then also how your affairs are handled during that incapacity and after death. So when we're talking about incapacity, this is when I say it's not all about death. If you were to get into a car accident and had to go through an extended hospitalization, your life still keeps going, right? Bills keep coming, and all those things need to be taken care of. And so estate planning handles both what happens to you if you're incapacitated, and then also what happens to all of your assets and your personal property and your real estate, after your death. So now we'll focus a little bit on the after death part. So what is an estate administration? I think what I want to make clear is that estate administration, I think we kind of interchange it with probate a lot of times, but probate is just a small part of estate administration. So estate administration is opening the probate and having the court decide where things go, but it's really collecting all the assets, inventory all the assets, distributing all the assets, and making sure we're paying creditors, and then closing the estate. So there's really 6 parts to an estate administration, and probate is just a very small part of it. And again, probate is a court supervised process, where the court decides who your heirs are, what your assets are technically, and then also who receives those assets. It's a public process, so you could go into county records right now and pull up somebody's probate, and you would see exactly what was inventoried during that process and who it went to. Many people are like I say here, like many families are surprised by the lack of control over the probate process. Since I practice in both Florida and Texas, I'll have examples from kind of both states to go through. But I'm actually working on a case now that was supposed to be, quote unquote, a simple transfer through heirship. And we've been working on this probably for 2.5, almost 3 years. It was one of the very first cases that I ever took in probate. And what we don't have control over is who is named an heir of the property. So my client is the daughter. Mom passed. Mom had 3 kids. 2 of the kids have already passed as well. Each of those kids had children. And so now the heirs are the grandchildren and my client, who is the only living child of that has survived. During their lifetime, mom and daughter had discussed and decided, hey, the house is going to go to you, right? The daughter. So it's going to go from mom to daughter. What has happened is, because mom did not have a will, we have to go through the court system to get that house transferred. And now we are dealing with 2 heirs. Well, technically 3 heirs. One we haven't been able to find. But we're dealing with 3 heirs that also have a claim of right to the house. They have never contributed to the maintenance of the house. They've never contributed to the taxes of the house, but they still are legally entitled to receive funds from that house once it's sold. An even bigger problem with that one is one of the heirs was incarcerated in a different state. He was released about a year and a half ago, but we can't find him. So while we have two heirs that are willing to sell their interest back to my client so she can control the house 100%, this third heir is just out in limbo. And so even if she sells this property, he will still have some claim to any revenue or proceeds that come from the sale of this house. Now, since we can't find him, his portion will sit with the state of Florida in perpetuity until he decides to claim it. But that is, that's part of the process, right? That's unfortunately why you need an estate plan, is so we can avoid situations like that.
So
Uh,
let me ask you a question. So
Sure.
that case, what if he's dead?
If we can prove that he's dead, then yeah, he will be considered have, as not part of the estate, and then it would go to my client 100%, right? Because we have the other two heirs that are willing to waive their interest in the property, because we basically told them, if you have to pay back your portion of the last 10 years of taxes and all that. And so they were happy to relinquish their interest. But if we can't, if there's no death certificate that we can find so far, so we have no proof that he's dead. You still have to present the court with evidence of death. And that kind of goes in, like I said, in perpetuity.
Wow.
Yeah, it's not a great situation for anybody involved in that. And the thing that I think really is upsetting my client is that these family members never came to visit her mother. Didn't even know really that she had passed, but now they're entitled legally by state law to a portion of the estate. And that's really upsetting. So
Yeah.
trust administration. I'll get into the differences between wills and trust here in a little bit. But trust administration, the biggest difference is it's a um, private distribution, right? There's no court involved. There is a will that is probated, but it's more so of like, hey, everything, if it's not, explicitly in the trust, this will says everything that I own goes to the trust. And then we just basically notice the court, hey, there is a trust, we'll be handling this privately. So that's what a trust administration is. It's basically all done in my office, and by my office I mean my home office, because we're a virtual firm. So most times you will see me over Zoom just like this anyway.
So you could be in Costa Rica as well.
I could be in Costa Rica as well. Um, that's the joy of remote notaries. I could hire a notary that's still here in the States to meet you, and we could be on Zoom handling most of this process. Again, probate is the court supervised process of distributing your assets. It's very public. It's often slow. Like I said, the only asset in that one case is the house, and 3 years later, we're still dealing with that. Um, Even what I call simple probates still take around 3 months to get through, because you still have to collect you know, all the assets and make sure that inventory is correct. You still have to, notice your witnesses, and you have to give time for the public to know that there's a probate going on. So I think your best case scenario, you're looking at probably 6 weeks for a probate, but most times they take longer than that. Um, and that's if everybody's getting along. If there's somebody that wants to contest a probate, you know, you have multiple attorneys involved, and it could be years before that estate is settled.
So that's why it takes so long when you have people that aren't in agreement. But
Most of that's when it takes longer.
Normally it would take like 6 weeks.
I mean, that's the best case scenario, right?
Right.
is 6 weeks. And that's if you have probably a single heir. Okay. Yeah, you have a single heir, right? And everything goes to her anyway, right? There's a will. If there's not a will, there's, a few more hoops we have to jump through. If the will is not properly, if it's not a valid will. So every state has their own kind of will criteria that would makes it valid or invalid. The biggest thing I see here in Texas is that there are not two witnesses. So Texas requires two witnesses, and it has to be notarized, or it can be handwritten. So the biggest mistake I find here in Texas is that the will does not have two witnesses.
Okay, one more question.
Sure.
Jerry wanted to know, so you don't have to go to probate if you have a trust?
Nope, that's the number one reason to have a trust. It is a what we call a probate avoidance tool. So if you have a will, you still have to go to probate. You still get to decide where your assets go with the will, but you still are dependent on it going through the court system to be finalized. And again, this is just a summary of the probate administration versus the trust administration. Probate is court supervised and it's public. It's very time consuming. Trust is private, generally faster, and the family controls most of that. Which one do you do? It really depends on your estate plan. Okay, so now we make that transition to talking about what is estate planning. It's a system. I think what I'm learning as I grow in this business. So I've been doing estate planning for, like I said, about 3 years now. And I think most people think, oh, I have a will, I'm good. Um, but really it's a whole system of documents, right? And again, it's also talking about what happens to you if you're incapacitated to get into an accident, and then also what happens when you pass away. There are 4 core documents that we talk about in estate planning. It's the will, the trust, a financial power of attorney, and a medical directive, living will, or someone making your medical decisions for you. So now let's get a little bit into what each of those documents do. Um, the will is what names your guardians. And when I'm talking about guardians here, I'm talking about for minor children. A will is the only place that you can name a guardian for your minor children. It also appoints the executor and that's the person that's going to handle all the details, right? Usually they do that in conjunction with an attorney, but it's that friend or family member that you trust, spouse, to handle the distribution and the inventory of all of your assets. Again, a will does not avoid probate. It is simply giving the court direction as to what assets you hold and where you want them to go. A trust. I like to think to explain a trust as like a bucket, right? And you have stocks over here, you have business interest over here, you have real estate over here, and all those specific assets go into this bucket. And the trust holds all those assets and then sets the rules on who can receive a distribution and when they can receive the distribution. Again, it has to be properly funded to avoid probate, but it is our number one probate avoidance tool that we use so that there is minimal court involvement.
What does properly funded mean?
So in order to be properly funded, all the assets have to be deeded to the trust. So like what we do as far as like bank accounts, usually you'll name a person that is a direct. I'm getting some feedback there.
Yeah, I just put her on mute.
Okay, got it. So with bank accounts, you don't want to change the name on your bank account to your trust, but you will name your beneficiary. So every bank in the United States, and I think most foreign banks also have it so that you can actually set who has access to your bank account when you die. Most of them have a transfer on death or some sort of beneficiary form that you can fill out. What we normally do is we will name the trust the beneficiary of that bank account, and then it automatically is funded into the trust. Your So there's a couple different ways that we do real estate. It depends on if it's your primary dwelling or an investment. Investments, we can normally transfer directly to the trust. Um, but your homestead, we normally will do like another transfer on death deed or a ladybird deed so that you still have complete control of it. Your insurance isn't affected or anything like that, but upon your death, it automatically transfers into the trust. So funding the trust basically means you actually are physically titling the things so that they're in the trust name and not your personal name.
Did that answer your question, Diana? You can come off of mute.
Somewhat. I just want to know the best way because I really want to avoid all the taxation and the court involvement and all the disputes that might come forth. We have a will and everything, so I know I'm going to probably need some additional help.
Gotcha. Yeah. Yeah, taxes, I would say, Texas doesn't have a state inheritance tax or anything like that. And
Virginia taxes you to the tax. They tax the tax on the tax.
yeah, and so there's definitely ways to avoid that.
Yeah, and that's what we want to do.
think that
A friend of ours, and I don't know what they did. It could have been a trust, but actually, he came by our house one day. He said, "I am officially poor. I have signed everything over, but they don't get it until after he departed."
Right, absolutely.
So that's
I
what we're looking.
I don't remember what the limits are in Virginia right now. I think they're around 6 million is when that kicks in.
Mm-hmm.
Federally right now, I mean, I hope to have that kind of problem. The limits are just under 13 million right now. I hope I'm worth 13 million um, by the time I get to my death, so that my heirs have a burden to worry about. Obviously, I will have written my trust in a way that it voids a lot of that for them, or at least carries on to the next generation and the generation after that. That's the
Is that
beautiful.
considered like having it in a living will?
No, so the living will is, I think it's in a few slides from now, but the living will is what determines what happens to you if you're hospitalized. So that's really part of
Okay.
medical directives.
More than medical stuff. Yeah, I need to really talk with you in terms of the trust then, as far as getting everything set up and set apart and different deeds and who
Yeah,
goes to what and where. Yeah.
we can definitely help you with
And
that.
is it just a mini trust or just one particular trust? So you have to have a trust with different aspects or like
Yes.
shoot.
Um, so like it's like I said, it's a very I won't say specialized, but it's a very custom thing, right? So you can have a special needs trust. You can have a lot of times what I do when there's minors involved, we do like a sub trust for each child, and that each of those sub trusts have different rules depending on their ages and what mom and dad want to do for them. I mean, we have uh, Medicare and Medicaid trust, if depending on how much assets you want to, I won't say hide, but basically not be in your name so you still qualify for those services, right? So there are, I think, somewhere on the range of like 75, 76 different types of trusts that you can create. Um, so yeah, it's
That's just the thing, knowing which one and how to best set it up.
yeah. And
And
that's where
that the property is in something, and then you want certain.
yeah, that's where your attorney comes in, right? So when we meet and have that consult, I'll ask you about your goals, I'll ask you about your assets, and that helps me determine what your plan needs to look like. And I, I have a whole matrix of things I go through to figure out what to recommend for you. And then you basically tell me, yes, that makes sense, or no, I want to change some other things. And it's a partnership, right? It's not just me, you're not dictating to me what needs to happen, because it's my job to help you make
Make
sure it's
the
done the
better
right.
decisions and
Right.
yeah.
So yeah, the financial power of attorney, we've talked about that a little bit, but that is you appointing someone that you trust to basically handle your money if you get incapacitated.
Mm-hmm.
And this helps you avoid the court having to appoint a guardian for you.
Mm-hmm.
Um, and when I'm talking about guardian in this situation, it's actually an adult guardianship. Um, it's also called a conservatorship. Depends on what aspect you're dealing with as far as property and things like that. So,
How how soon or how the time frame as far as going to an effect, or is there any kind of a weight limit, or is it
for the financial power of attorney,
for any as far as even to set up the trust? I know, like, whew, making sure everything is gotten in, like these different
yeah.
things. Prop-
So once it's drafted and signed, it's in effect.
Mhm.
Um, Funding is the thing that we are normally pushing our clients to get done, because there are certain things that we can't do. Like we can't go to the bank and have the trust named as the beneficiary, but we depend on you. Like we give you instructions on how to do it, but
Mhm.
we don't
When you
have.
say funding to do that, is that based on the amount of your asset?
Nope. You can
What?
have $1 and it'll still transfer. Um, how we deal with the amount is, and is how we, I guess, the distinctions in what kind of trust that we draft, right? So we can have a spendthrift trust that will basically only allow people to take what they need, and then we define needs as like basically education, health, and then there's other kinds of trusts that we can do, like a business interest trust, right? So, and this is why I say it's very custom. So I do have clients that have small businesses, and then we have to go in and make sure that their business documents accurately or will allow their assets to go to their trust. And so it could be as simple as, what I do for a college kid, which is everything goes to mom and dad, or I have, multi-million dollar estates that we're dealing with where they have multiple businesses and there's not the same partnerships in each of those businesses, and they each have different key man policies for those businesses. So it runs the gamut. That's why I say it really depends on
Mhm.
what assets you have and what your goals are. I have some people that just don't want everything to go out to their family outright, and so they put it in a trust,
Yeah.
because they want to make sure that it will sustain them for many many years, right?
Mhm.
Um, that's the primary reason I think that I'm seeing people do trust now is not that they don't trust their family members, but if we're really talking about generational wealth, then putting all the assets in a trust, hiring somebody to continue to monitor the trust and help it grow so that the assets um, will increase and it feeds not just the next generation, but the generation after that. That's a lot of what I'm seeing now. And so now the healthcare documents, like you said, the living will. So the living will is what you would give to your hospital to determine whether or not you want to be on long-term care, meaning a respirator, whether or not you want it to be resuscitated. That's a difficult word for me. Um, what else? Whether or not you want to be an organ donor,
Mhm. Pretty
whether or
much
not
stagnant.
you
Yeah.
want to be go to a rehab center or come back home. So there's really you're determining what kind of care you see. That's the living will. Your healthcare power of attorney appoints the person that makes that decision. So those are two documents that work in tandem. All right. So we've kind of been talking about this all along, but why does this even matter, right? These documents all work together so you have a clear authority on who is in control and what the plan is. It allows for smooth transitions and hopefully reduces stress. And really, the number one thing that we try to avoid is being in court, because it is kind of a tedious and time consuming and it could escalate pretty quickly on the financial side. I know On the estate planning side, I do primarily flat fees, and that runs from a few hundred dollars to a few $1,000s. I think the most expensive plan I've ever written is probably $7,000. But again, they had multiple businesses and a lot of things that had to be done. On the probate side, that's an hourly fee for me. And right now, my bill rate is $500 an hour. And if you're looking at, a multi-year probate, I'm billing you for every second that I'm working on that case. So it could be 100 hours. I mean, who knows how long that probate could take. And so that could be very, very expensive. And then if you have, family members that are contesting, they each have attorneys that are involved that are billing them at whatever rate they're billing them. So that whole probate process can get very expensive very quickly. So we try to avoid courts as much as possible. So you can have two people that have different outcomes depending on whether or not they've planned or not. So again, with the plan, you get to choose the beneficiaries and you decide who those decision makers are. Without a plan, state law decides and the judge controls the entire process. So if you want to, avoid some judge that's never met you and doesn't know your family, if you want to avoid them making decisions for them, create a plan. All right, the will versus trust. I think we've talked about this quite a bit as well, but it's the speed of access to information with the trust, right? You don't even have to tell the court other than, hey, this person has died, they have a trust, we'll handle it privately. With a will, it's going to take longer. We don't know how long, but with the trust, we're talking about days, maybe weeks. With a will, you're looking at weeks, probably more like months. Again, the privacy, wills are all public record. Everything is divulged in court and remains on the public on those websites. There are some things that are redacted, but for the most part, your entire inventory list of assets is public record. With a trust, it's all private. Nobody knows what you own. I even tell people, don't even put the name of your trust in your name, right? Have it be some random name because you don't want anybody to be able to track it back to you at all. Another thing, this is kind of true for both wills and trusts. So I think there's a stronger, it's probably stronger with trust as far as the family harmony, because if done correctly, it's completely avoiding any kind of court system. There's very little that anybody contest in can contest in a trust. And even within that, I like to put things in the trust that say, hey, if you contest this, you don't get anything, right? So hopefully by doing the trust, you avoid some of those family conflicts. With protection versus exposure, you can do asset protection in a trust that you can't necessarily do in a will. It depends on the asset, but yeah, you can protect that from creditors. You can protect that from other family members. I'm doing working with the family now. It's second marriage for both of them, both the husband and wife, and they don't have kids together, but they want to make sure that their particular assets go to their children, and so we're doing that in the trust. And that's a much easier process to do than having to go probate each of those individually and deal with separate property and community property. And so yeah, it's much easier to do with the trust. The hidden risk of not having a plan. We definitely have. I've hit on this a bunch. Most people don't plan for incapacity, right? So that is, if something were to happen to you tomorrow, who's handling your affairs? Is it your spouse? Is it your children? But if you don't have the power of attorneys in place, they have to go to court to get that power, even though that may be the person that you want in control. they legally can't do anything. They can't access their bank account. They probably will, right? If your passwords are saved on your, on your Google password, they may have access to it, but they can't go into a bank and do anything, right? Um, the second one is minor children. Don't you want to be the one that determines who your kids go to and how they're taken care of? The only way to do that is through planning. Um, and the only way to do that within planning is to name that guardian in a will. I will say that's the only time that even if you have a trust, you still have to go to court if you have minor children, because minor children can't take in a trust. You have to be a legal adult, which in Texas is 18. Um, so that is one caveat to even having a trust. If minor children are inheriting, they still will need to go to court to get that guardianship taken care of, because custody does not equal guardianship, legal guardianship. So those are two different realms. Real estate and business outcomes. So this is a situation that this is not my case, but it's one I've heard in masterminds that this particular person passed. They had a will that they had done through trust and no through LegalZoom, I believe, either trust and wills or LegalZoom. But that will did not account for any of their rental property that they had, and it did not account for, like, in the rental properties. Not all were held in the same partnership, and so they still ended up in probate because they never actually spoke to an attorney to determine what happens to that real estate and how those entities were supposed to be dissolved when he passed. Right, so that's another reason to speak with someone about your plan. The last one is cost. Like I said, my typical engagement on a trust specifically is between $3,000 and $4,000, but that same case can cost you. Right now, my minimum uh, retainer on a full probate case is $6,000. So right there, you're already spending double on the probate than if you had just, spent the $3,000 up front to do the plan. You're already saving your estate $3,000 right there. So the bottom line is that estate planning is a gift. It's a gift for your family. It is a tool that allows less stress on them. In the future during that probate process, and also if you get incapacitated, right? Who you work with matters. I personally don't have any problems with LegalZoom or trust and wills and trust and wills. I forget the name of what it comes to, but if you do that, get the upgraded plan so you actually physically talk to an attorney so they can help you, um, so that there's someone that understands your goals and what your assets are, so that everything is addressed in your will or in your trust. The really, I guess the most important thing is the process happens either way. Whether you have a plan or you don't have a plan, you're going to pass at some point, and your assets will be distributed, um, either by your plan or by the state's plan. And that's all I have for you guys. So I appreciate you guys listening to me for however long we've been up here. That's my contact information. It's my email and my office phone number, and that QR code takes you directly to my calendar. So if you want to book some time on my calendar, you're welcome to do that as well.
I have a question. It's the elephant in the room.
All right.
$3,000
Yep.
upfront. Are there
Yep.
payment plans for that?
There are payment plans for that.
Okay.
Yeah, there are payment plans for that.
If you
I
guys
have,
have any questions, you can come off of mute.
okay.
Oh, go
I
ahead,
do.
Jerry.
Hi. Yeah, I'm in a dilemma because my dad is like 92 years old and he has a
Mm-hmm.
will and he lives in the country. And the lawyer that drew up his will just took his money because it doesn't really say anything. The only
Okay.
thing that's clear in the will is that I'm the executor, and can do all the stuff. But
Mm-hmm.
his assets. It doesn't say, because he has real estate, he has rental properties as
Yeah.
well as the house. It doesn't say, who gets what or how that's
How to
divided
do
up.
it.
And I've been trying to convince him that he needs to do a trust because this
Yeah.
will is not going to suffice. And we're going to be tied up in court forever trying to figure it out, because I know for a fact one of the heirs would be contesting, because I already know this, and that's what I told him. So I don't want to be in the middle. He puts everything on me, because I'm his favorite, and he trusts me. But but the fact is, and like I told him, but I might not. You 92, but you might outlive me. But the bottom line is something needs to be clearer than what he has right now. And
Yeah.
so I've been trying to convince him. I almost got him sold, but I just hadn't found anybody for him to work with. And then I
Yeah.
work on my own stuff. But I want to get that situation cleared up first.
Sure. Yeah.
Yeah,
I mean,
so that
you'll
we
definitely
can,
end up in probate if those properties aren't addressed directly in the
right.
will.
And that's what I was telling him. I'm like, yeah, the only thing that's clear is that, because I have a stepsister, the only thing that's clear in there is she's getting a specific amount of money, and that's it, because she didn't grow up with us and she has no attachment to the properties or anything,
Gotcha.
in Cleveland. So yeah.
Yeah.
So I will be contacting you because I need some help.
Absolutely.
Yeah. And all your consultations and everything you say is on Zoom.
Yep.
Yeah.
Until the very last one. You'll get to see me probably in person at the signing. It kind of depends on what
What we come up with. Yeah.
what you come up with and where we are,
Yeah.
at the time. I still go back and forth between Florida and Texas. So,
Okay.
and if I'm on Vanda's plan, then I'm gonna be living in was it Ghana? I'm gonna be living in Ghana, or no,
Ghana, Cape
Keep-
Town,
Cape
Oh,
Town.
somewhere.
okay.
I'm gonna be
Yeah.
living in Cape Town with Wanda, so
I understand. But yeah, so I will be contacting you, and then I can always take my computer and we can go there and do it with him, because he
Yep.
definitely has to be involved. I can't do it without him because it's his
No.
property. But yeah,
Yeah, like I have to check capacity and all that kind of stuff.
right,
So
right, right. Yeah, no, he's still in his right mind. He's 92, but he's still functioning well. But still,
those are some of my most fun clients, because they there's no holds bars at that. It's
oh yeah,
100% authentic and truth at that point.
yes, yes, yes. Okay, thank you.
Absolutely.
And so those that aren't in the state of Texas, like Diana, she lives in Virginia.
Hmm.
That's my question.
How would you work with her?
Yeah. I cannot draft your plan directly, but I can definitely help you interview attorneys. I'm in a ton of networks. It's similar to what we do in real estate, right? Like
Fine.
I have partners all over the states, and so I'm happy to help you find an attorney that can do what you need done.
Recognizing this is a red city and a red state, and this are trust issues, and we're in a precarious
Understood.
situation in terms of with redlining and redistricting. They just want to figure out a way to get rid of it anyway.
Understood.
And that's saying a lot without saying a lot, but you
Yeah.
picked up on it.
Yeah. Oh, I
Thank you.
know.
Thank you.
Absolutely.
I took a screenshot of your information, so
Okay. Great.
get in touch with you. Thank you.
And the website is the same. It's just urethalaw.com, or so. But I like people to get to me directly. So I not that I avoid the website, but it's a pretty basic website. It's just going to tell you to call me or book an appointment. So
And your consultation fees for referrals, is that still based on the hourly rate?
for you guys, since we sat through here, I'll actually
And
waive my fee.
now, okay, go ahead.
But yeah, my consult fee is 1 hour's worth of work. So $500.
Okay.
But you say
But
you
if
waive the fee for us,
yeah, if you
Oh.
mention that we
that we were
when
on
you're
this
booking
call.
that we are on this call, I'll go ahead and waive that for you.
Thank you.
Yeah.
Yes, ma'am.
This is so needed. I think that different organizations should just probably have you on speed dial to have you really no seriously about that to help educate the communities and especially ours that don't
100%.
feed us that information so that when people do and and that's a constant thing when you get to be 35 twice plus six as people are going all the time and there's no age factor and these
Hmm.
things are not in place. I
It's
wanted them to have a trust or now more so than a will, and we perish lack of knowledge. So
yeah,
that
those stats are kind of staggering, right? Like if you look
mhm,
nationally, it's somewhere around 70% of people don't have a plan. So 70% don't have a plan. Within our community, it's upwards of 90% of people don't have
90%, yeah,
a plan. So, yep.
because
Mm.
it's not been ingrained or taught, and then it's not been accessible to us. So I think
Yeah.
have you on speed dial and just be able to get out to the different communities, the different churches, organizations, and then have us better prepared so that all of the properties and the hard work and labors that we have acquired over the years with the blood and sweat and tears and all the other things we've had to be to put up with, that is just not lost.
Well, this is how we grow as a community, as a people in general, right? We set the next
Yes.
generation up. And there's so much stuff that I didn't go into as far as like what you put into a trust, how we grow the trust, right?
Mhm.
How we take care of the property when it's in the trust and afterwards,
Mhm.
like you get an insurance policy that specifically is used to, pay off the house when you pass. Like there's, what policies or what tools do you use as
Mhm.
far as your 401k and
Mhm.
and growing that do you use to take care of your children? What kind of provisions do you put in your trust that takes care of them? So yeah, that's what I say. It's a very custom thing.
Yeah.
So I have to speak pretty general when I talk
Mhm.
about these things, but obviously when we sit down for a consult, we go through. My checklist is like 18 pages long. I'm not even joking. So
Wow.
Okay.
Sounds like we need a part two.
Well, that's what my question is. When we do because this says 15-minute discovery call or whatever,
yeah.
we need to have all of our information
Now,
with us
so
then, or
that call we go through what the process is, and then so it's really three parts, right? So that first 15-minute phone call is me explaining what the process, how it actually works. So not this presentation, but what
Mhm.
it's
mm-hmm,
like to actually create a plan. Um,
mm-hmm,
then that's when I give you what I call my inventory at my asset inventory. Like I said, it's 18
Mhm.
pages. So besides the stuff, it also talks about like what are your goals? Are there any non physical, non tangible things you want to pass down? Because it's my belief and my philosophy that legacy is not just money and things; it's also the impact you leave on people. And so we go through that kind of thing too. So like, are there spiritual aspects you want to leave with people? Um, are there educational things that you want to go through? And so it's more than just stuff. And I typically say 2 weeks to go to put that together, so it gives you time to think through it because you're not only thinking about the things and the goals, but you have to figure out who the people are that you want to include in as beneficiaries, also who you want to include as your executor or your personal representative or your trustee. And you need time to work through that because mm, hopefully this is sparking conversation within the family, right?
mm-hmm,
And allowing you to really sit together, have a family meeting, and go through those things. So there's also paperwork in there about your you know your final planning. Like, what do you want your funeral to look like? What do you want a funeral to do? Like, what does that look like? So that's a pretty extensive process. So I say 2 to 3 weeks to get through that. Then we have another meeting, and that's when we determine what your estate plan actually looks like what specific pieces go in, what trust do you need besides just the main trust, what sub trusts go in there, and that's how we determine pricing. So I have packages, right? I have a young family plan, I have business plans, and there's different add-ons in there. So we go through specific pricing in that second meeting, and because that's when I have time to review everything with you, and then another 2 weeks, 2 to 3 weeks for me to write it, um, draft it and review it. And so then we'll have a third meeting that is what I call a review meeting. And we go through everything to make sure it matches your goals that we talked about previously, and also to make sure there's no misspellings or anything like that. So once we do that review, generally takes me about a week to get through that. And then we have the signing meeting. At that signing meeting, we will have either you provide the witnesses or I provide the witnesses, and the notary will get everything finalized. And then it's good to go. From then, that's when the funding comes in. So if it's real estate and I know about it beforehand, I will go ahead and draft those deeds myself. And then I will give you specific instructions for your 401ks, your IRAs, your banking, how to get those redefined or retitled to go into the trust. So yeah, it's like I said, and this is why it's important to talk to a person, right? Because you guys don't know to do all of that if you're going through wills and trust, right, through a website. And that's a lot of times how these things fail, is they're not properly done, even because you're just filling in blanks, but nobody tells you, hey, you need two witnesses, right? And it needs to be notarized, right? And so,
But if my name is already on the bank accounts, will I still need to put it in the
you
trust
don't,
or
yeah,
whatever?
in that situation, you wouldn't put the trust as the bank account
Okay.
unless you want to change all your checks over, which I don't
Yeah.
recommend,
No.
right? So in
Okay.
that case, we'll set the beneficiary of that account to the trust.
Okay.
Yeah.
Okay.
You mentioned as far as deeds,
Mhm.
when there are several deeds involved,
Yep.
that you have to do something in terms of.
Yeah, so most of your property is either in the name of an LLC or your personal name, and depending on what you want to do, I will need to retitle those deeds. I will need to redraft a deed and put it into the name of the trust. Most times, what we do, if it's in an LLC, we'll keep it in an LLC, and we'll just move the property interest, or yeah, the property interest of that LLC to the trust. But then we'll also need to put some language into your LLC documents that says, hey, when I passed, I allow this to move to my trust. So it's a little bit nuanced there as to how we actually move small businesses around.
Now
I
with
have a question. Right.
technology, I'm sorry, go ahead, Anna.
I have a question right quick.
Sure.
You mentioned partners because I have property in Tennessee.
Mm-hmm.
And there's an attorney that I've met just within the last 2 years that's semi-trustworthy, but it's always good to have two or three.
Agreed. Yeah. So property is probated or handled in the state that it's located in. So if you can move, you can definitely move it to your trust. But if for some reason, like, your partner's in another state, like it kind of goes by the rules of that state, if that makes sense. So your property interest will move to whoever you decide it moves to. Like, it can still be a part of your estate, but for as far as like redeeding it and things like that, that will need to be done in the state where the property is located.
Okay.
So if we're drafting a Texas estate plan or a trust, I would still need to contact a Tennessee attorney to have them draft that deed that puts that property into your Texas plan. Does that make sense?
Yes, it does.
Okay. And
Thank you so
again,
much.
I have ways to network and either have it done for you through a referral or assist you in finding someone in Tennessee that can do that for you.
Okay. Okay. I
I
have
have,
one other. Go ahead. I have one other. No, I'm not going to ask this question. Go ahead, Dana.
no, go ahead, because mine was about AI.
Okay.
So go ahead.
I if there I had a family member that remarried but had a 401k, and on that
Mhm.
401k he had his name and two grandchildren's name. He didn't have them as the saying on it wasn't when he died. that they were the whatever you call it, I can't even think of the word now, beneficiary.
Mm-hmm.
He just had their names on there. So he remarried in 3 months after he remarried. Uh, he died.
Okay.
So the person that he had married, their names weren't on it anywhere.
Nope. So it'll still
Uh,
go to those grandchildren.
it didn't work like that. It was such a mess. It was a mess. It was a
Mm.
because the grandchildren were underage. They were teenagers. They were in
Yeah.
another state, and
They had to get a guardian appointed and do all that.
so none of that. So uh,
Interesting.
by the time we found out that it should have went in probate, uh, it was like 6 months later, and they'd already had the court date and did everything, and the 3 month wife got everything.
Oh, wow.
That's interesting.
Very.
Mm.
It's a long, drawn out story behind it, but
Is there
it's
there's
been a mess. It's been a mess. And now it's gone into 13 years, so it's probably going to be
that's
a
wild.
loss. It's a loss, but
Yeah,
it
so
was a mess then, and it's still a mess.
with 401ks, those are direct beneficiaries, so they are not actually considered a part of the estate. So they go to whoever is named as the beneficiary. If there is no beneficiary, then it goes back to the state. I believe it depends on, oh, I'll take it back. It depends on whether or not it's through the government or it's a private. So that can
It
change.
was a government.
Yeah, then
He
the
worked
government
for the
probably take that
government,
money
so
back.
I figured that in the end, the government probably took the most of it because the person that actually was married to him didn't know cat from dog.
Yeah, if it's a government or a state program, or a state or federal program, the government takes that money back.
I figured
Um,
that's what happened, even
and
with
generally they have to name a beneficiary, and that has to pay out over 10 years. And so if it's already been 13 years and you're already past the statute of limitations on that. So
Well, thank you.
thank you so much.
absolutely.
Okay, I got one last question. It has to do
Yes,
with
ma'am.
AI because my husband is always talking about we got to get this trust, we got to get this trust, and he figured he wrote it up on Chat GPT and all that. And I said, you still got to get an attorney to, do the part. So what's your recommendation with that?
As far as like I review documents all the time. So um there's obviously a fee associated with that, but it's not as much as me um drafting a fee or drafting the trust. I will review it and make sure it meets all the technical standards. I it will okay, so there's kind of two types of review, right? I can review it and tell you not whether or not it's valid, and I
Mm-hmm.
can review it and tell you whether or not it works.
Okay.
Those are two different things. So
Okay. All right, that's all I have, and I appreciate your time. And it is exactly 8 o'clock. I didn't think we'd be on here this long, but you guys had some great questions, and thanks for your
Thank you
participation
so
and for
much.
your attendance.
absolutely.
Thank
Mhm.
you.
And yeah, reach out to me anytime, guys.
Okay. Thank you so much.
All
Appreciate
right,
Awesome.
it.
Have a good night.
Much.
You
Thank you.
too.
bye-bye.
Good night.
Bye-bye.
Bye-bye.
Bye.